Hello and welcome to the Minimum Competence episode for Monday, October 27th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, a furloughed IRS lawyer selling hot dogs, Trump's crypto forward CFTC pick, and Exxon suing California over climate disclosure laws. Let's remember, without craft, inspiration is a mere reed shaken in the wind. And read today's legal news. On this day in legal history, October 27th, 1978, key provisions of the Copyright Act of 1976 officially took effect, modernizing U.S. copyright law for the first time in nearly 70 years. Although signed by President Gerald Ford in 1976, the act delayed implementation of its core provisions until this date to allow for public and institutional adjustment. The law marked a major shift in how copyright was conceived, particularly by aligning U.S. law more closely with international standards. One of the most important changes was the extension of copyright protection to unpublished works, which had previously existed in a murky legal space. The act also introduced the concept of works being protected once they were, quote, fixed in a tangible medium of expression rather than requiring publication or registration, making protection more automatic and accessible. It moved away from the fixed term system, previously 28 years with a renewal, toward a life plus 50 years standard for most works, further updated to life plus 70 years in 1998. Additionally, the law provided for fair use codification, laying out a four-factor test still used by courts today. It also clarified authorship and ownership rights, especially in the context of work-for-hire arrangements, and created clearer paths for compulsory licensing of certain works, including music. The Copyright Act of 1976 thus ushered in a more author-centric and technologically adaptive framework. It was designed with an eye toward the emerging digital era, even though it predates the internet. The act remains the backbone of American copyright law today, regularly referenced and amended as new challenges arise. In what I guess could broadly be considered a feel-good story, Isaac Stein's pivot from federal tax attorney to full-time hot dog vendor during the government shutdown is equal parts charming and quietly damning. With the IRS idled and thousands of public workers furloughed, Stein has taken his sidelining as an opportunity to live out a childhood dream, running a hot dog cart named SHYSTERS, complete with moon pies, RC Cola, and a slogan that reads, "The Only Honest Ripoff in D.C." Wearing his usual business suit, he blends satire and performance art while serving construction workers, telecommuters, and other locals near the D.C. metro. What began as a quirky weekend hobby has become a daily operation thanks to the indefinite work stoppage. Stein, 31, brings a regulatory lawyer's precision to the permitting process and a people's person's flair for sidewalk commerce, referencing old-school D.C. aesthetics and childhood nostalgia with every dog he serves. Customers who can explain the cultural significance of RC Cola and moon pies even get a nickel off, an appropriately ironic twist in a city where billions of dollars are stuck in limbo. But the charm of this setup, a suit-clad lawyer slinging hot dogs under a punny sign, shouldn't distract from the underlying issue. Stein, like hundreds of thousands of other federal workers, is benched, not by choice but by political dysfunction. He can afford to make it into an art project, while others can't. The shutdown has real economic and emotional consequences, and not everyone has the resources or flexibility to turn lost income into a pop-up business. As clever and good-humored as SHYSTERS is, it also reminds us that doing something fun is not a substitute for stable governance or paychecks that come on time. President Donald Trump has appointed Michael Selig as chair of the Commodity Futures Trading Commission, or CFTC, signaling a continued push to make the U.S. a global hub for digital assets. Selig, currently the CFTC's chief counsel for its crypto task force, confirmed his selection alongside David Sachs, the White House's lead official for AI and crypto policy. Both praised the move as aligning with broader goals to modernize financial regulations and support innovation in digital markets. Selig stated he would prioritize freedom, competition, and innovation while helping establish the U.S. as the crypto capital of the world. His appointment follows a series of pro-crypto policy moves under Trump, including passage of the Genius and Clarity Acts, both aimed at creating clear regulatory frameworks for cryptocurrencies. Selig replaces Brian Quintenz, whose stalled nomination was reportedly derailed by lobbying efforts from Gemini co-founder Tyler Winklevoss. The episode highlighted tensions within the crypto industry over regulatory leadership. Selig brings both public and private sector experience to the role, having previously worked at the law firm Wilkie Farr and Gallagher before joining the CFTC in March of this year. His appointment reflects the administration's continued alignment with digital asset advocates and its willingness to reshape financial oversight around emerging technologies. ExxonMobil has filed a lawsuit against the state of California, challenging two newly enacted climate disclosure laws that require large companies to publicly report greenhouse gas emissions and climate-related financial risks. In its complaint filed in federal court, Exxon argues that Senate Bills 253 and 261 violate its First Amendment rights by compelling it to endorse views on climate reporting it disagrees with. The company contends that California's mandated frameworks are misleading, unnecessary, and conflict with existing voluntary disclosures and federal regulations. SB 253, set to take effect in 2026, targets companies earning over $1 billion annually and requires them to report both direct and indirect emissions, including those from suppliers and consumers. SB 261 applies to firms with over $500 million in revenue and mandates disclosure of climate-related financial risks and mitigation strategies. Exxon says the laws amount to forced speech and overreach by the state, particularly given the overlap with federal disclosure requirements. While tech giants like Apple, IKEA, and Microsoft backed the legislation, major industry groups such as the U.S. Chamber of Commerce and the American Farm Bureau Federation opposed it, calling the mandates burdensome. California has defended similar environmental policies in the past, but the outcome of this case could shape how far individual states can go in regulating corporate climate disclosures, especially when federal standards already exist. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here tomorrow, and until then, remember, creating is like driving down a foggy road toward a house. Slowly, you see more details of the house, the color of the slates and bricks, the shape of the windows. The house is there, but you can't see it all at once.